And the first case we are going to hear arguments on this morning is State of Ohio versus Michael Birch. Looks like this, did the state waive?
Yes,
Right,
the state waived.
State waive, so council, you'll have 15 minutes. We have read the briefs and we're prepared to proceed if you are.
I am, Your Honor.
Very good, thank you.
Good morning. I'm Attorney Patrick Lanahan. Actually, I think a notice of appearance was filed on behalf of my brother David, who's actually the assigned counsel on this matter. He had some medical issues, so I
Hope he's okay.
Oh, thank you very much, and I appreciate the time. I'm going to be brief, as you just mentioned. The brief was filed. There was a response brief, and we did file a reply brief. The issue that I wanted to really focus on today is the Rule 29 motion, which was not granted by the trial court. We believe that the particular code section that Mr. Birch was charged in this two separate count complaint, which is 2917, 21A5, that's a unique statute that's generally not charged against most people. The A1 and A6 sections are generally charged. This particular code section requires that somebody from the residence specifically contact the defendant and or contact the person charged and direct them not to call for whatever particular reason. However, the alleged victims in these particular charges, one is the ex-wife, and the other one is an aunt, but she's actually the daycare provider for the child that the defendant and the ex-wife had. So it's unique in the aspect that we believe that as a matter of right, Mr. Birch had every right to reasonably contact both of the alleged victims. And I say reasonably, I mean, if he was threatening in some nature, then the A1 or A6 code sections should have been charged. And since it wasn't charged in this particular case.
So A5 on both counts?
That's correct.
Wasn't there testimony, though, that the wife had called and told him numerous times not to contact her?
No, it was just the opposite. It was not the ex-wife, it was the aunt. And then she would contact him because she was a daycare provider. So there was a little conflicting type of testimony where I think she, really the testimony from her was, I didn't like the content of some of the communications rather than truly being directed not to. She had testified she didn't want to be part of the divorce matter, as it were. And therefore, really as a matter of right, I believe Mr. Birch had every right to contact. Again, reasonably. I mean, if he starts threatening, it becomes a different scenario.
So your argument is he was charged under the wrong subsection?
That's absolutely correct, and therefore the Rule 29 motion should have been granted by the court. Notwithstanding, the evidence that was presented was he had made apparently 40-some phone calls, and I use the term 40 because that was the number that was used at trial. And some of those were apparently over a couple-year span. So the question really is, what would be the relevance of those 40 phone calls unless they were inappropriate phone calls, if they were threatening in some nature, where in this particular matter it wasn't. I think even the state acknowledges that it's the quantity of the type of calls that was made, and quantity should never be the issue. It's not the quantity of the evidence, it's actually the evidence itself, and in this particular code section, we believe wasn't violated, and so the Rule 29 motion. To be quite honest with you, I'm going to make the following statement. I think this is a chilling case for divorce litigants, where parties have a child, and there should be some communication as it relates to the child. To simply bar that person from calling by saying, you can't call me, is a chilling effect upon litigants, and I think it sends the wrong message. Again, if he was threatened.
But counsel, you have other means of communication without calling. And, domestic relations court usually tells them to use family record.
Well, that's if the parties agree. The court would have to order it. In this particular case, that was one of the means of communication. The point, though, is The ex-wife never responded or answered any of these calls. These weren't calls that she had received. They were messages left saying, hey, what's the status of our child? And in this particular case, on August 21st, 2018, apparently the child had been injured, and the ex-wife refused to communicate the status of the injury. And it may have been minor in the scheme of things, but the bottom line is she never accepted any of these phone calls. She never communicated with him. And frankly, if we want to use the domestic relations scenario that some communication should have been used through our family wizard, then she had a duty to do that. Now, I'm not trying to suggest that, again, his conduct was totally appropriate. Called 40 times over a couple-year period of time. If they were inappropriate conversations or communications, that might be an issue. But the specific conduct as he was charged on these dates, there was nothing inappropriate in any of those communications.
Counsel, so that I'm clear on, as it relates to the wife, the phone calls were the charged activity, not the text messages. I was trying to determine if those were all lumped into one, or if we were talking about separate things, because there's reference in the briefs to the text messages.
Exactly the point. There was allegedly one particular date for an allegation, and they threw so much into it, 40 phone calls or whatever the number actually was, to suggest that text messages, phone calls, OFW messages, all of these were communications that shouldn't have been. In fact, there's some reference, even social media was the claim in this particular case. Let's throw enough against him and suggest to the jury, excuse me, suggest to the jury that all of these in an accumulation of matters, excuse me, all in an accumulation of matters is the problem. So I agree with you. I think that was inappropriate for the court to allow that to
Well, I'm just trying,
occur.
yeah, I understood the argument. I guess as it relates to the case though, and as it relates solely to the issue with the former spouse, is the date that's on there, was that the text message communication or a phone call communication? The date charge?
There was nothing presented by the state to answer your question. And that's the problem. And if they didn't even establish that, they didn't even establish one of the essential elements of the effect. And it's not an on or about matter. This was apparently August 21st of 2018. It was unclear from all of the testimony as to whether or not any of this conduct occurred on any of the particular dates that was charged. The other date was April 18, 2018. I know that goes to the aunt, but the bottom line is nobody authenticated when these, or testified as to when these alleged incidences occurred. They just said, here's all the information, figure it out. And I believe that the jury lost its way by doing that on the accumulation effect, and that wasn't the thing. One last thing I wanted to respond, and I know I indicated I'd be somewhat brief in my argument here. This is kind of an analogy of the following, respectfully. A person is charged, the police find somebody and they find a can of tuna or whatever. I think in our brief we argued pears or some fruit. And they actually stole something else, but they're charged with stealing X and actually they stole Y. Well, just because you present X, if you don't show the Y, then you don't have the case, and that's what's here. It'd be an analogy of the following. Charge a person with theft, but you only come upon the person with receiving stolen property. You don't actually prove the theft, but you've got them having the particular item, like a motor vehicle or something like that. Well, you can't convict the person of theft unless you have the elements of theft. You can clearly convict the person of receiving stolen property, but if you charge him with theft, that doesn't mean that because he has the mere possession, that you actually prove the theft. And we believe this case was analogous to that the state didn't prove that Mr. Birch committed this particular offense, notwithstanding the chilling effect that I think it has on divorce litigants. In light of that, we respectfully request that this court reverse the decision of the jury in this particular matter remand the matter and vacate his conviction. If there's any other questions, that's all I have for today.
All right, well, thank you for the arguments this morning, especially given the late notice that you received. You did a nice job arguing the case. We'll take the matter under advisement, issue a decision in due course. The clerk of courts will mail you a copy, or your brother a copy of the decision on the day it is released. He can also check the Supreme Court of Ohio's website where the opinions are posted. Thank you again for
Very
your
good.
appearance.
Thank you very much, Your Honors. Have a wonderful day.